Right, here I am at Knowsley Safari Park in Lancashire, just outside of Liverpool. Well, here I am at Knowsley Safari Park, just in the picnic area. It's an excellent safari park just outside of Liverpool, which I implore you all to come and have a look at. They've got an excellent bat enclosure, birds of prey, carnivores. Hope I don't see any of those today too closely. Elephants, as well as honeybees, primates, some rodents, and ungulates, animals with hooves. So I thought you could have a look at some footage I have taken of some of those animals. And as you look at my amateur Sir David Attenborough efforts, I would explain to you the case of Grant and Edwards. And the citation for this common intention constructive trust case is 1986, square brackets, Chancery at page 638. This is an incredibly interesting mid-80s case regarding common intention constructive trusts and the extent to which a lady's contributions to general household expenses could be referable to the acquisition of property. So essentially here you have a man and woman living together. The property is purchased in the man's name. There are no direct contributions to the purchase price or mortgage instalments by the woman. And the question before the court then therefore is whether the woman's contributions to general household expenses could be taken into account in relation to the acquisition of this property. So the battle for value, as we'll see, is between the man on the one hand and his brother, who are the legal title holders, and then the lady, who's of course the non-proprietary owner who's claiming a beneficial interest. So here are the facts. Well, the plaintiff, let's say Grant, separated from her husband and set up home with the first defendant, that's Edwards. And in 1969, Edwards purchased a house and moved into it with the plaintiff, with Grant, and their child and two children of the plaintiff's first marriage. Well, the house was conveyed into the joint names of the first defendant and his brother, although the brother had no beneficial interest in the property. This activity had been solely done for the purpose of assisting in obtaining a mortgage for the property. The first defendant, Edwards, said to the plaintiff, and this is important, that her name was not included on the title because it would cause her prejudice in the matrimonial proceedings which were pending against her husband. So in other words, to what extent is this some form of excuse, some kind of activity by Edwards, which is perhaps in itself indicative of some interest that she had that he was trying to suggest she didn't? Well, we'll examine that through the Court of Appeal in due course. So then he, Edwards, pays the deposit and the mortgage instalments in terms of the financials, while the plaintiff, Grant, makes substantial contributions to the general household expenses. So they're the financials. Substantial amounts from her, which are so substantial, in fact, that without them he wouldn't have been able to make the mortgage payments. The family live in the house until it gets damaged by fire when they move into a council house, council accommodation. And they get some money from an insurance policy which covered the risk of fire, which is used to repair the house. And thereafter it was let, and the remainder of the money was put in the parties' joint account. Well, they separated in 1980, and then the plaintiff, Grant, claimed a beneficial interest in the house. So it goes up at first instance before Judge Baker QC, who was sitting a judge of the Chancery Division, and he dismisses this claim. Well, of course, Grant is not happy, so she appeals and goes up before the Court of Appeal in the guise of Sir Nicholas Brown-Wilkinson and Lord Justices Mustill and Norse. Brown-Wilkinson, of course, at this stage is the Vice-Chancellor. goes on to become Lord of Appeal in Ordinary. Well, they follow the Court of Appeal's judgment in Eves and Eves and say that the fact that Edwards felt the need to make an excuse for the house not being conveyed jointly into Grant's name indicated a common intention that she would take a beneficial share, and that Grant would take a beneficial interest if she had acted to her detriment in reliance on that intention. And that could be shown by her contributions. As a piece of an aside, we should say that this would not be enough on their own, or this would not be enough on its own, and that something more may be needed. So, in other words, when we're coming to this question about trying to divine a common intention and the ingredients that might be needed, we first look to the name of the parties and where that was purchased or who purchased it. But if it is a sole legal owner, as in this case, equity can infer a trust where there's a common intention that both have a beneficial interest in the property. So what does that mean then in terms of result? Well, of course, the excuse that was given by the first defendant, that's Edwards, to the plaintiff, that's Grant, for not putting her name on the title, would cause her prejudice in the matrimonial proceedings, in his view. But that, of course, for her here, raised a clear inference of a common intention that she should have an interest in the house. And her general household expense contributions were well in excess of what would be expected as a normal contribution. Ergo, these indirect payments were indirect payments towards the purchase of the house, and she had acted to her detriment. And as a consequence, she was entitled, pursuant to the deployment of Common Intention Constructive Trust, of a half interest in the house. So think about Grant and Edwards, particularly in the context of the mid-1980s deployment of Common Intention Constructive Trusts, perhaps as a bridge from Gissing, Pettit, Eves and Eves, Hussey and Palmer, etc., through to Lloyds Bank and Rossett and the 90s cases. So Grant and Edwards as a bridge, and Lord Brown Wilkinson in that case and his brethren. So on that point, I hope you've enjoyed the scenes of the animals, and I bid you goodbye.
Hey, don't bite that, you little git! Well then, there are the facts in Grant and Edwards, that Common Intention Constructive Trusts case. I hope you've enjoyed listening to the exposition of the case whilst viewing the various scenes of the animals here at Knowsley Safari Park, which is very nice. Well worth a visit, you must come. And you'll see the various animals. So far I've not seen really any dangerous animals, at least I've not been in danger. Mind you, I've not been out of the car, this is the first time, but oh my god, what's that? Ah!